See, just as relationships are based not solely on love, but more so the need for something and the ability to satisfy that need, so is the everyday interaction with what people do, what they can do, how they can do it, what they cannot do, how they cannot do it. There's a underlying perspective that these public actors are supposed to just automatically behave a certain way. Just like people presume in a relationship that, well, because I have this perspective, you must love me or you must accept the same perception. Just as much as relationships are really not love based, relationships with these public actors is not strict to their bound performance because there are always other things involved. Just like a relationship whereby a need exists and that other party has the ability to satisfy that need, whether it be monetarily, whether it be sexually, whether it be emotionally, other aspect of life, whatever it is. One party is willing to let go or overlook certain flaws that that man or woman has because they have the ability to satisfy some of their needs. And because of that, slowly as time goes on, a type of bond exists, a type of attachment comes to life, and that is loosely referred to as love and things of that nature. There are always exceptions, but for the most part, relationships, that's really how they work. Someone has a need that the other party can satisfy, and because of that ability of that other party to satisfy that need, the flaws of certain flaws that will be usually not overlooked are then overlooked. That's why you look at certain people in certain relationships and you wonder why this man is putting up with this aspect of a woman or why this woman is putting up with this aspect of a man. It's because that man has a need that woman has the ability to satisfy. So they're willing to overlook certain attributes, and that creates a certain type of bond. Now, that itself might give birth and give rise to something worse if it's not entertained as time goes on, where both parties are not bettering themselves and they're just solely relying on the need to satisfy something. That's what happens with the everyday man who say they have rights and they have this expectation for these so-called public actors. There's a bond and attachment that exists in people's mind based on expectation that these people will perform a certain way or that certain things are to just predominantly exist. Especially those finally figuring out that, okay, this thing called the Constitution exists and that all public actors are bound by it. One still has to know what their need is and whether these parties are capable of satisfying that need. If you don't know what your needs are, you would not be able to properly demand it. Or else you will settle for less. And when you settle for less, you will suffer. This thing that the everyday man, the public at large, has with these so-called public actors is a relationship. A relationship that is no different than any other type of relationship. When it all boils down to it, it is really that simple. When it comes to the right of use, right of access, properties, land, usufruct. Usufruct is a right to use and benefit from a property, while the ownership of which belongs to another person, meaning you don't own it, and it's probably disputable that you don't own it, or undisputable, it's very clear that you don't own it. Nonetheless, one reason or the other, give rise to your right to use and benefit from it, despite you not owning it, whether it's clear or vague. The person who enjoys the use and benefit, aka usufruct, that's what usufruct is, the use and benefit of something that doesn't belong to you. The person who enjoys the use and benefit of that which doesn't belong to them is called the usufructuary. The usufructuary shall maintain the property as a reasonable owner, meaning you are now the caretaker of it, and shall not cause damage to or diminution of the property, except where the property is subject to natural depletion over time. Since you don't own it, since it is not yours, yet for whatever reason you have the ability to sharecrop and benefit from it by use. And by virtue of you not owning it, despite you being able to use it and benefit from it, you must maintain it. Usufruct is part of the principles of public trust doctrine. Remember, we're speaking of the relationship of the public at large with the so-called public actors, right? An exception to that is natural depletion over time. Believe it or not, the concept of usufruct is also where the concept of amortization, depreciation, and appreciation comes in, when you basically write it off with some type of investment with properties and whatnot in business. In modern civil law, the usufruct is divided into perfect usufruct and imperfect usufruct, or quasi-usufruct. And there are three different ways one can have the right to use and benefit from property that they don't use. The first way is perfect, second, imperfect, the third, quasi. For perfect usufruct, the property is used without changing the nature. In the latter being imperfect usufruct, the property cannot be used without being consumed. For example, money, food, etc. Disposable things, meaning the moment you use it, it ceases to exist or it becomes depleted. So in that case, the exception where the property is subject to natural depletion over time comes in only for an imperfect usufruct. A perfect usufruct, which is a type of right of use of a property to benefit from it, despite you not owning it, is that you use the property without changing it in any way, meaning you must maintain it. That's the first type of usufruct. The second type of usufruct, which is imperfect usufruct being your ability to use and benefit for something without you owning it. The second type is the nature of it makes it consumable, makes it disposable. But the usufructuary, you, or the one who doesn't own it but is benefiting from it, when it comes to imperfect usufruct, despite it being consumable or disposable, you're then liable to deliver the owner at the end of the usufruct the same value or the same quantity and quality as the beginning of the usufruct. Restitution. If something that you are using that is not yours, that you're benefiting from, is something that depletes by virtue of you benefiting from it, then it is your liability, your responsibility to make the owner full and complete again, to restore the value of that thing which you used that did not belong to you in the previous state prior to you sharecropping or putting it to use. Imperfect usufruct is also known as quasi-usufruct. So usufruct, in summary, is a right in your ability to use and benefit from something that does not belong to you. For whatever reason, whatever the intricate situation is, you're able to use it despite it not belonging to you. And there are two types. First type is perfect usufruct, whereby when you use it, just take care of it and make sure that it's not reduced in value. The other type is imperfect usufruct, whereby the use of it naturally causes some type of consumption, depletion, or disposability of that thing being used. But despite it being consumable, you must still restore them after you've used it. So regardless of whether it's a perfect usufruct or not, one thing is consistent. You must always leave it in the condition as it was previously, without alteration of its substance or value. But you have the right to use it and benefit from it. The question you ought to have in your mind now is, since this is about property and the use of it, there are many different types of property. Corporeal and incorporeal property. Corporeal being physical stuff that you can come in contact with and interface. Incorporeal meaning not so much physical, such as intellectual property, trademarks, intellectual property. None of this is isolated. Whenever someone sues that in legal's name, and you've somehow properly established it as an intellectual property, and you've separated the presumption that that thing is not you, and to the people making the presumption that you can't copyright your name, the problem is not the fact that you can't copyright your name. That is well known. The problem is the fact that you think that thing is your name in the first place. One needs to first reverse and first figure out whether that ens legis is your name or not. Then begin to entertain whether you can copyright your name or not. To come to a conclusion that you cannot copyright your name is an affirmation that a predominant misunderstanding exists that that thing is your name in the first place. But many people are stuck on that rudimentary stuff and just don't quite get it. So there's usufruct and the two main types of usufruct. On your respective state level, the right of use of property is wholly entertained within either something called a Bill of Rights or the Declaration of Rights, just as much as it's entertained on a federal level, the United States Constitution, or the preceding documents to that. At Illinois, it's in Article 2, Section 1, 2, 13, and 19. One being that all men by nature, free and independent, and have certain inherent and inalienable rights. Among these are life, liberty, pursuit of happiness. To secure these rights to the protection of property, to secure these rights of life, liberty, and pursuit of happiness, that is inherent and inalienable, meaning it can be separated and stripped away from you, and it cannot be granted upon you, hence it's inherent. And these things that are inherent that cannot be granted upon you or separated is your rights to protection of property. By virtue of that, certain body politics called governments are instituted among these men who will have inalienable and inherent rights, and these governments derive their just powers from the consent of the governed, which are those men who have inherent and inalienable rights. 2. No person shall be deprived of life, liberty, and property without due process of law. That which is inherent that cannot be granted upon you, and that which cannot be stripped away from you because it's inalienable, shall not be done so without due process of law. And there has to be a very good reason why. Remember, we just went over usufruct. Your right to use someone else's property based on one primary condition being it must never be damaged. It must never be damaged. And then by virtue of it never being damaged, there are two main ways it can use it. And the way it can be used is in a manner whereby it can be depleted. And if it's depleted, you have to restore them based on restoration. And 2 is, even if it's not restorable because it's not consumable, then you must not damage it. It must be in the same condition it was before you left it. Remember that foundational principle our parents used to tell us, leave everything the way you find it? These are foundational principles of usufruct that our parents were instilling in us, unbeknownst to us. And these are based on inherent and inalienable rights. Right inside the household. It might have seemed a little bit harsh, a little bit too mean, but they knew what they were speaking of. Subsection 13 of Article 2, Bill of Rights, Illinois Constitution, 1870. Private property shall not be taken or damaged for public use. When you see this word use, usufruct, same thing. Now, the exception to that usufruct being your ability to use it. Remember, usufruct just means your ability to be able to use something even if you do not own it. But guess what? The lack of ownership and the right of use is tied into a property that is public, because there are private properties and then there are public properties. And inherently, everyone has the ability to obtain, retain, and perpetuate by protecting private property, and it cannot be stripped away from them. Alienable rights only exist where a private right of action exists. Again, inalienable rights exist where a private right exists. Inalienable rights exist where a private right exists. There's public and there's private. Private property shall not be taken or damaged for public use without just compensation. This first clause regarding property and its use strictly refers to private property. It is now being very specific on how usufruct applies. Generally, usufruct applies where the presumption exists that you can use it, but where private property is in the equation, someone must be compensated, and that compensation exists if the private owner consents to it, and that's called due process, where no person shall be deprived of life, liberty, or property without due process. So even if you are saying, hey, I'm going to compensate you, right? No, that's part of the law. Well, due process say that I still have to agree or disagree. Why? Because these things that I own are my property. Your rights, by the way, are also your property. They are inalienable, meaning you cannot strip them away from me. And guess what? It's inherent. You cannot grant it upon me. Just because you're trying to grant me some monetary compensation for this private property of mine, I can choose to strip myself from it or not, because it's inherent to me. I have the inherent right to retain and protect that which is mine. But of course, if you don't know what private property constitutes, how to prove that it's a private property, how can you invoke this, right? Such compensation, when not made by the state, shall be ascertained by a jury and shall be prescribed by law. And this by law includes contract law, because you're dealing with private contracts now. And where private property exists, private contract goes hand in hand. The fees of land taken for railroad track without the consent of the owners thereof shall remain in such owners subject to use for which it is taken. Meaning, there's now an interest of public use versus one man's use. If the land is being taken to create a railroad track to help thousands of people to commute and make their lives better, now they call that a countervailing interest of the government, literally. And this is where the public trust doctrine comes in. Meaning now we're trying to take these natural resources, these lands. See how everything is coming together with the public trust doctrine we went over in the past? Now we're going to be taking these public lands to assist other people, because, well, we are the trustees and we're meant to protect natural resources for the benefit of the people. So now there's a countervailing government interest based on the interest of the public. The fee of land taken for railroad tracks, meaning they still have to compensate you even if they take it for the use of the public, without the consent of the owner, the private property owner thereof, shall remain in such owner, meaning even if they take it for the use of public based on the interest of the public to benefit a lot of people, shall still remain in yours, even if somebody compensates you for that amount. Specific, aka subject to use for which it is taken. But also, for the sake of equity, people still have to benefit from it. So the question now is, are these entities purporting to be private government, which is created for the benefit of the people because governments are instituted amongst men, deriving their just powers from the consent of the governed, which is you? If they're trying to take your private property from you, are they really using it for the benefit of the public at large? Because they will use and milk this thing called for the purpose of the public safety, or for the purpose of public interest, or they will invoke vicariously this thing called the public trust doctrine. Question you ought to ask yourself is, these entities coming to take your land to put it to use, is it for the purpose of the general public at large, your fellow men and women, to which you have delegated the power upon them to be able to do certain things? If it cannot be shown and proven as such, then they are merely private corporations coming to snatch up your property. And the principles of due process automatically kicks in, and you have the right to challenge usufruct. Why? Because of Section 19 of the Illinois Article 2, 1870 Constitution. Every person ought to find a certain remedy in law for all injuries and wrong which he may receive in his person, property, or reputation. He ought to obtain by law, right, and justice, freely and without being obliged to purchase it. Now you're not supposed to be purchasing your land back. Why? Because you never consented for them to take it in the first place, and it was not meant to benefit the public at large. So some people will pass away and give their land or their library to the public schools or public this, or create a library so that the public could come in and come read and whatnot. But that's a different thing. If you did not consent to it and they still took it by force of arms and did not prove that it's for the benefit of the public at large, and that those consensus actually agreed to it based on contract, and you were able to prove it, and they simply use military power, which is abrogated in subsection 15, the military shall be in strict subordination to the civil powers, to take it, then subsection 19 and subsection 1 kicks in automatically, where every person ought to find a certain remedy in the law for injuries and wrong which he may receive in his person, property, or reputation. He ought to obtain by law, right, and justice, freely and without being obliged to purchase it, completely without denial, properly without delay. To tell me, people going through a mortgage situation, the fact that they were using that property as a collateral for a loan simply means that you already owned it. Because if you never owned that property in the first place, you would have not been able to use it as a collateral for a loan. So if you already own the property that's being used as a collateral for a loan, why then are you taking out a loan if you already own it? Why are you using a property that you already own to be used as a collateral for a loan to then own the property itself? Somebody is engaging in the different types of fraud that exist. Either it's extrinsic fraud, which is a type of fraud that is used in order to prevent you from being able to enforce basically everything here in subsection 19, any given right of action, or intrinsic fraud, which were specific actions used to engage in the fraud itself, or actual fraud, which is the fact that someone knew something you did not know and they relied on your inability to figure it out, and you relied on that misrepresentation, which eventually damaged you. These are the basic foundational principles people should be dealing with when they're dealing with mortgage, along with National Bank Act and National Currency Act, along with functioning through trust, because now you're speaking about preservation of private right of action. The only way a private right of action can arise is if you have a private interest in any given property. It's all about interest. And the best way to introduce and implement private interest in property is through asset protection method of this thing called trust. None of these information are isolated. Absolutely none of it. In order for you to really win a battle, you must think from different angles, because they are coming from you from different angles. That's why they create the mortgage electronic system, the MERS system, which is a trust of its own, according to Security and Exchange Commission. But nonetheless, if one doesn't know these basic things and how it applies on their state level, because when they file that lispendus against you, they're going to either the county court or the state court. They're not taking it to a federal level. And that automatically gives right to the common law of the state, which will force you to look into your state constitution. Because there are now civil procedures on the state level that must be in harmony when it comes to that usufruct that they're trying, because that's all they're doing with the mortgage situation. They're all claiming usufruct, the right of use, because of the rights and obligation of contract that you have entered into without due process. An abrogation of subsection 1, 2, 3, 13, and 19. Now, of course, your state constitution will say similar verbiage. So it's incumbent upon you to look into your state constitution for this similar verbiages. And do they not use military power over you when they tell the sheriff to come kick you out? That's if you're soft enough to let them do that. This is where putting all the parties on notice beforehand comes in, for them not to do such a thing. But if you've not properly secured your interests one way or the other, how then are you going to be able to do anything? This basic comprehension of how property right works is extremely important. The mortgage system is where a lot of people are losing a lot of livelihood. Think about it. Humans need some basic things: love, food, shelter, air, water, that stuff, right? Mortgage, houses, and land, a shelter. These people are stripping you of the most basic things that humans need, that you require to sustain and perpetuate life, liberty, and pursuit of happiness, which was mentioned first as being something inherent and inalienable, that property of yours and your right to it branches out from. On the United States level, it tells you that cruel and unusual punishment shall not be inflicted. Whenever they deprive you of life, liberty, and pursuit of happiness based on one of the basic things that you need in life, which is shelter, that is cruel and unusual punishment. In the past, we've run over the elements that qualify what cruel and unusual punishment is. That will be implemented into the things that you put into pen and paper. It then tells you, in all criminal prosecutions, which we all know according to federal rules of civil procedure, and all state laws, which we all know that there's only one right of action according to Rule 2 of Federal Rules of Civic Procedure, which most of these courts are homogenized into based on the incorporation doctrine, that there's only one type of action, which is civil action. Right here, one form of action. There's only one form of action, a civil action. So whether they call it criminal prosecution or civil or not, it's just all civil. It's all pen and paper, because all of that cannot be enforced without putting something into pen and paper and some type of participation which will bring it to life. Hence, there's only one form of action called civil action. And on Patreon, we went over in details the incorporation doctrine. In all criminal prosecution, which they will come at you with the right of use, usufruct, whether it's mortgage or something else like easement. The accused shall enjoy the right to speedy public trial, which never occurs, by an impartial jury, which never occur, of the state and district wherein the crime shall have been committed. Well, most people never get an impartial jury because they don't know whether they need a grand jury or a jury, or how to select it through voir dire, which we went over in the past on YouTube here. Which district shall have been previously ascertained by law, and to be informed by the nature of the cause of the accusation. You are never informed of the nature of the cause of the accusation, because if you were informed of the nature of the cause of the accusation, you would understand the intricate details as to that thing you signed called a mortgage, and the promissory notes involved, and who they sold it to, and all that stuff. In the past, whenever they assigned this contract by selling it and fractionalizing it, they never even used to notify people of it until certain case law saying, all right, well, you have to notice them. You have to give them notice of it being assigned. Nonetheless, it's an open way out right there. To be confronted with witnesses against them, which never occurs in any given dispute with property right, whether it's mortgage or not. To have compulsory process of obtaining witnesses in their favor, which was spoken of right here in subsection 19. The person ought to find a certain remedy in the law for all injuries and wrong which he may receive in his person, property, or reputation. He ought to obtain by law, right, and justice freely, without obligation to protect it completely, and without denial, and promptly, without delay. To have compulsory process, due process, for obtaining witness in his favor. Amendment 5. Nor deprived of life, liberty, or property without due process of law. Nor shall private property be taken for public use without just compensation. Same foundational principles, just placed in different places, but similar and harmonious intent. The right of the people to be secured in persons, houses, papers, and effect against unreasonable search and seizure shall not be violated. No warrant shall issue, aka the writ given to the sheriff to come kick you out, but upon a probable cause. What is a probable cause? Supported by oath or affirmation. So is there usually a probable cause regarding that writ is given to garnish your checks? Is there usually a problem, which by the way, your earning is your property also, your sweat equity? And even one step further, if it's being paid to the accounts of your trust, and you're simply the laborer on behalf of the trust, there are probable cause for it. Is how you should lay your property and asset protection. Is there a probable cause for that employee of that sheriff department to come and kick you out by the use of military power? Is there? Supported by oath or affirmation. I'm particularly describing a place to be searched and persons or things to be seized. So when it comes to the search and seizure of physical persons during an arrest, we went over the elements, the deep prescription of what probable cause is, because probable cause is not defined. They don't define the definition of the terms. They don't define the terms used within these things. But when it comes to things like other types of properties, like intellectual properties or your land or your house, what is a probable cause as regards to usufruct and your ability to put it to use, or the ability for others to not put it to use? That is the important question you ought to be asking yourself. But nonetheless, let's put that in abeyance for now. Think about it. Marinate on it. Hey, I'm inviting you to join my Patreon if you haven't already. Over there, we speak about things that we don't speak of on YouTube. We speak about trust-related matters and other subtle details regarding property and asset protection. We speak about financial-related matters and a lot of things that people seek and can't quite put their hands on or get a better understanding of. We speak about child support, privacy, things of spiritual nature, subtle arts of suing and whatnot, discharge, and much more. Take a look at it. Take care. Best of luck.